Now, his conduct can only be understood as an intentional effort to obstruct us. And so we think this is obstruction. We've enclosed documentation of the entire deposition, and we hope you prosecute him. Oh, gosh.
We thought you were interested in this judge position. Why are you defending one of these people that we want to investigate in the January 6th investigation? So
Stanley
all
Woodward.
that history is why we think it's now appropriate to bring in Jack Smith why we've asked him to come in.
I actually think any individual in this country who was victimized by Jack Smith at the Justice Department ought to be able to sue in a private right of action in any organization. I think this kind of litigation will help expose this sort of dirtbag that Jack Smith was.
A criminal referral for one of Jack Smith's top henchmen finally coming down. The first Jack Smith criminal referral to Pam Bondi that we've seen here, and it's a good one. Jim Jordan sent this out from the Judiciary Committee over in the House of Representatives, and it's a big one because we know Thomas Wyndham came down and had a deposition, and in this memo over to Pam Bondi, we got 193 pages. We'll, of course, hit the cover letter from Jim Jordan explaining why this guy should be prosecuted. And this is Thomas Wyndham, to put a face to a name, walking out of court, carrying his law books like he's really sophisticated. Use the internet now, but okay. So he says that now this guy is worthy of criminal prosecution. And as we know, this little domino effect that happens, the first domino knocks into the other, the cases spider web out, and we follow it where it may lead. But the Jack Smith team has been long part of our scrutiny here, and so we're happy to see some developments in this arena. But Jim Jordan posted this, says, now we're referring Jack Smith's former deputy, Thomas Wyndham, to the DOJ to be prosecuted. Over to you, Pam. Says, read the full referral over here. We'll do that happily. Posting this on the 19th of November, saying today, Jim Jordan referred Thomas Wyndham, former senior assistant to Jack Smith, the illegitimate prosecutor, to the DOJ for criminal prosecution. Why? Because Wyndham declined to answer nearly every single one of our questions, and then made up various reasons for that. Now, as senior assistant to Jack Smith, Wyndham has unique firsthand information about the work that office did. Yet, despite being given express authorization by the DOJ, right? Pam Bondi comes in and says, oh no, we don't need to exercise any privilege. Feel free, run your mouth, man, talk about everything. He still declined to answer questions. Now, these topics, when we brought him in, included a bunch of things. Knowledge of a February 2021 proposal that another prosecutor called J.P. Cooney brought to the FBI to investigate Trump. Okay, they were all coming after him, and then they just handed their homework over to Jack Smith, and then they called it independent. Also, interactions and materials that they got from the J6 committee that we saw in the J6 own writings, in the committee's own letters. They said, we're going to continue to provide information to your office there, Jack, on a rolling basis. Information related to the surveillance of Scott Perry and the seizure of his cell phone. Information about how many members of Congress were investigated as part of Arctic Frost and Jack Smith's investigation. And communications about evidence in possession of the Willard Hotel. Now, Thomas Wyndham, Jack Smith's henchman, refused to answer nearly all of the questions, and now he needs to be prosecuted and indicted immediately. So hopefully Pam Bondi got the memo. But here's the letter. To Pam Bondi, the Honorable Pam Bondi, from Jim Jordan and the Committee on the Judiciary out of Congress. They say, all right, Attorney General Pam, the Committee on the Judiciary writes to you to refer significant evidence that Jack Smith's prosecutor, Thomas Wyndham, former senior assistant to Jack, has, by his conduct during a deposition in front of Congress, obstructed a congressional investigation, just like James Comey did. Now, he was a witness, and a witness violates the law when they corruptly obstruct or impede the endeavors of Congress, and that is a problem. Congress cannot perform its oversight function if witnesses like Thomas come here, and then they corruptly refuse to provide any information that the law requires them to provide. The obstruction of a committee investigation undermines Congress's core constitutional oversight obligations, and now we're giving this to you, Pam, so you can investigate all of this evidence that we're about to dump out on you. Now, the Supreme Court, they say, has recognized that Congress has a lot of power, and the rules authorize us to conduct oversight, including sending subpoenas to witnesses. Now, pursuant to these authorities, we're asking questions about Jack Smith and the rigged investigation, rightfully so. Now, as a part of our authorized inquiry, the committee sent a letter to Thomas Wyndham back in April. We said, hey, Thomas, can you come out here for a voluntary interview? We've got questions about your role as a prosecutor on Jack Smith's team. And since you're a civil servant and a career prosecutor, surely you'll do your duty to your country, right? And come answer some questions about your flawless execution of your law enforcement duties. The letter provided a non-exhaustive list of examples of alleged misconduct by Jack Smith's corrupt team. And the committee's request did not limit the scope of the information or seek any conditions on the testimony before we got approval from the DOJ. Okay, so he's former DOJ. They say, DOJ, do you have any problems? Are you going to object to us asking any of these questions, this question or this question? They say no. But nonetheless, the DOJ did authorize his testimony. They said, no, go talk to them, no problem. In an email dated dated May 29, 2 weeks prior to his initial voluntary interview, the DOJ provided Wyndham and his attorney with the anticipated scope of our questions. 4 topics, 20 subtopics. Can you come in and talk about it? Then on June 4th, the DOJ consolidated and organized these items into 5 topics and granted Wyndham authorization from the DOJ. Yeah, you can talk about all those things. DOJ is not going to invoke any privilege. Go wild. Then they gave him another accommodation to ensure that he would speak on 3 different occasions. We gave his attorneys topics that he could prepare for. But rather than raise concerns about any of this or seek clarification about the nature of what we were going to ask him, he came into Congress and he declined to answer multiple questions during this interview on the inaccurate basis that the DOJ had not authorized testimony about those topics. Oh, I can't talk about that. DOJ says I can't. They say, no, they literally say you can. For example, Wyndham, Jack Smith's prosecutor, invoked an absurd, indefensible interpretation of the DOJ's authorization by refusing to testify about communications. He says, well, FBI officials are not DOJ officials, so the FBI is different than the DOJ. The DOJ can only give me permission for DOJ officials. He said, well, the FBI works and is organized under the DOJ. He said, well, it's still FBI, so I can't answer any questions about that. Here's how that went down. All right, Thomas, did you ever have any discussions with Mr. D'Antuono about seeking information from the Willard Hotel? And D'Antuono was, I think, the special agent in charge of the DC office. The same guy who's like, I don't know what happened to the cell phone data of the January 6th bomber. Now, I think he says, Wyndham, well, I think that falls into 2 different prohibitions. I mean, what I said before is that I know who Mr. D'Antuono is. And when you asked me that, whether I interacted with him or whatever the specific question was before me, I pointed you to the department. They have not authorized me to. He says, yeah, but Mr. D'Antuono is a department official, so you're authorized to talk about him. So he says, well, so for that reason, I won't be able to talk about any specific interactions with Mr. D'Antuono. And this is a prosecutor, of course, working for Jack Smith, who's interfacing with the FBI. Well, I can't talk about that. Beyond that, the question that you most immediately pose seems to me, this guy, to the extent that it occurred or did not occur, my understanding would fall, as my counsel indicated, within Rule 6 obligations, which would further prevent me from discussing that with you. It's like, oh gosh, he's one of these dudes. No wonder he was on Jack's team. He's like, perfect. He's like, this guy can just run his mouth and just say nothing. In addition, attorney chimes in. Your request to the department specifically named those 2 agents, and this guidance letter to us does not. It says on the letter, we said we wanted to ask you questions about department officials. It says that on there, correct? Well, FBI agents are not Department of Justice officials, as I understand the term. They say, what? Are you stupid? That's ridiculous. FBI is a part of the Department of Justice. Attorney chimes in, well, I understand that, but I don't know that it is a Department of Justice official. But anyway, regardless of whether this is an official or not, any interaction with him, I'm aware there's a newspaper article that prompts this line of inquiry, which is supposedly about a subpoena to the hotel, as you said. Any subpoena issue would be by definition a grand jury subpoena, and therefore that topic is off limits because of the grand jury rules, as indicated on page 2, and so his lawyers like coming in with like lawyer technobabble because he doesn't want to answer questions. Now, this position, they say, is clearly nonsensical because the FBI is a component of the DOJ, and the DOJ specifically told his attorney that the committee would ask questions about this. Then Wyndham came in, and they refused to provide certain details. No names, no information about the other prosecutors that he worked with during the investigations into Trump. Nothing. Citing lack of department authorization. These positions are in literal direct conflict with the department's clear direction to provide information about these topics. So then Wyndham, he came in and he says he also relied on what the committee considers to be an overly broad interpretation of the rules. Now, while the department's letter did note limited exceptions, we're not going to talk about the grand jury stuff, okay? The question posed by the committee were only tangentially related to that. And he still refused to answer questions about what may have happened with the partisan J6 committee, as well as his interactions with the FBI to get the billing records from the Willard Hotel. Now, his conduct during this interview contrasts starkly with the way other department employees have handled this rule before. In fact, this Congress, the committee has conducted transcribed interviews with a bunch of other people, including J.P. Cooney. For example, former special counsel senior prosecutor J.P. Cooney, also on Jack's team, he came in and he talked about it. He said he had communication with staff on the select committee about obtaining information. Yeah. Admitting Jack's team colluded with Liz Cheney. Likewise, department tax attorneys called Jack Morgan came in, Mark Daly came in. They talked about all their interactions with the FBI, including investigatory steps and evidence collection. Viewed in context of this, Wyndham is the odd one out. And then he turned around and started making privilege assertions. Now, after he refused to testify about the topics that we told him to come in and talk about, the committee issued a subpoena. We said, all right, if you're going to come in and play that stupid game, come in voluntarily. We work with you. You're wasting our time. Here's the list of questions. Any objections? No, we'll be there. Then you get there. Then they just stonewall you. They said, all right, enough of that. Now you're getting a subpoena, Tom. They sent him one back on July 21st. Says, you better get your butt back here. You better reappear and retestify about these topics. In advance of the depo, being very very nice to him. On September 4th, they wrote to him again. The DOJ said, hey, Thomas, you can give unrestricted testimony about everything. Says unrestricted testimony. Specifically, the department, the DOJ, gave him a list of topics that said, you can talk about all these. So if you come in and say you can't, it's written in stone. See it. DOJ explained that given the extraordinary events underlying this, unrestricted testimony includes everybody and all agents in the department. Now, despite this authorization, this dude came in again. On September 30th, he declined to answer, again, nearly every single question, citing various shifting justifications. Specifically, his lawyer began the deposition by asserting numerous blanket objections to our ability to depose Wyndham. He says, well, he has First Amendment privilege. He's got attorney-client privilege. We've got a belief that the committee has no legislative purpose for this at all. And Fifth Amendment rights against self-incrimination. It's like, why? Why are they so opposed to just answering questions? I mean, if their investigations are so flawless and they did everything by the book, why can't they just say, no, this is what we did, since they're public servants? Because they know that they're totally busted. Pursuant to a House deposition rule, they gave him a copy. They said, well, okay, you can raise your objection. Then you have to make them non-argumentative and non-suggestive. Okay, like lay down your objections and then move on. Now, in response to at least 70 questions, this civil servant and career prosecutor, he replied with some version of the following response. He says 70 times in this depo. I respectfully decline to respond for the reasons stated by my counsel, over and over like a broken record. When the committee sought clarification about which one of the reasons justified his refusal to answer questions, he just kept saying Fifth Amendment. I respectfully decline to respond for all reasons stated by my counsel. Then the committee said, well, what's your reason for this question? He declined. He offered vague, repetitive, evasive responses, declined to respond for all the reasons. He even declined to answer questions that were already previously answered during his voluntary interview. And so now his refusal to answer nearly all the questions, it obstructed our fact-finding. As a senior assistant to Jack Smith, he has unique knowledge of this, but despite being given express authorization twice, he declined to answer any questions, including these: knowledge of a 2021 proposal that Cooney brought to the FBI, interactions with materials that he got from the J6 illegal committee, what he was doing with Scott Perry's cell phone, information about Arctic frost, FBI evidence in their possession from the Willard Hotel subpoena. This obstruction is very apparent, they say. Other witnesses came in and testified. JP Cooney came in and he testified. He said, well, Jack Smith's team never considered how seizing Scott Perry's cell phone would interrupt his duties as a member of Congress, while Wyndham refused to respond to any questions about that. In addition, Cooney also testified, another Jack Smith prosecutor, that he had communications with staff on the committee about obtaining information in the report. Now, Wyndham didn't do that at all. He objected to every single question that was posed to him. Now, he also, Cooney, the good prosecutor, the better one, he also testified that he did review some CHS information, but Wyndham wouldn't answer any questions, period. Now, he thus chose a different course. Now, although the DOJ had specifically authorized him to testify, he flouted our right to ask him questions. Wyndham's insistence on refusing this deprives our committee of work and doesn't give us info about Jack Smith. But Wyndham corruptly obstructed this and our committee by withholding information from us. They say he acted corruptly. Let's see how they define this. Now, to be clear, this referral does not result from a good faith disagreement about the scope of the rules. He just simply refused to answer any questions at all. And this conduct went far beyond. This is intent to obstruct us. Now, despite previously providing the committee with certain limited information, he then refused to confirm any of that information during his depo. And to the extent that his transcribed interview, and when he did invoke his fifth, there's strong grounds to conclude that any Fifth Amendment privilege was raised with respect to those questions, since he already talked about it. So when he came back the second time, he improperly refused to talk about these things that he must talk about. He testified during the first conversation about the inception of the Jack Smith investigation. Question to him, or his answer rather. He said, the first detail was to the U.S. Attorney's Office for D.C. Okay, and when did that detail begin? Well, he says, I don't know, kind of middle of November 2021 maybe. And were you asked the detail, or did you seek out the opportunity? I was asked to go on a detail, to go get Trump, okay? Fast forward in the transcript. Was the focus of the investigation on the events that occurred on J6, or was it really more about the 2020 election? When this detail was formed, what were you working on? He says, well, there wasn't investigative information that had been developed during the course of the investigations into either on-the-ground rioters who breached the Capitol, and then also what later became the conspiracy cases as a shorthand, which may involve people like the Proud Boys and the Oath Keepers, both trials we covered here, where they may have not actually, in some instances, entered the Capitol. Yeah, no, Stuart Rhodes wasn't even inside the building at all. And same thing with Enrique Tarrio. Never there. Not even in DC, Enrique. So those are the sorts of investigations where I began looking at the files. That was during round one. However, round two, he comes back. When asked about these topics during his second deposition, he then refused to provide any information information about his November detail. They said, hey, Thomas, you testified in June about what you did at the DOJ. You stated that the first detail was in the District of Columbia. When did that begin again? I respectfully decline to respond. Okay, you already answered this in June. You answered that question in June. You said, here, like November 21. Would you like to confirm that? I respectfully decline to respond. All right. You testified about this. I respectfully decline to respond. And over and over and over. Further, during his June interview, he also testified about his detail of Jack Smith's office. He said, well, the next detail was to Jack's office. And when did that begin? He says, well, he was appointed, I believe, November 18th, and I began the detail to that office shortly after Jack Smith came on board. But during his deposition, again, at the second round, he says, I'm not answering that question. You were a member of the special counsel's team, correct? I decline to respond. Now, in addition, despite previously testifying about all these things, he invokes his Fifth Amendment when asked about his interactions with 9 people during the depot. He refused to answer whether he attended meetings with Garland and Jack Smith, although he talked about it before. In June, here's what he said. And prior to Mr. Smith's appointment, it appears that Garland had summoned prosecutors to Main Justice to flag for them the impending appointment of Mr. Smith. Did you go to the meeting on November 18th with Garland? Okay. Was I involved in that meeting? Yes, says Wyndham. And who else was in the meeting besides you and the AG? Well, there were a number of people. Maybe I can describe it. I was advised that day that I was invited to a meeting, and Garland comes in. He's at the head of the table. I can't recall if he sat down or if he's standing up. It's a brief meeting. He says something to the effect of, without recalling the exact words, it's like 3 years ago, you know. He says, thank you for all coming on short notice. I wanted you all to know that I've decided to appoint a special counsel. That special counsel is Jack Smith. I don't remember the exact words, but he said it shortly thereafter. Then he went and announced it publicly. I recall him saying something like, you know, I hope that y'all will continue working with Smith, or that y'all will consider working with the special counsel, you know, something along those lines. And when was the first time you met Smith? Sometime first week of December. And how often did you interact with him when you were on the special counsel's team? He says daily. But then he comes back. Question, did you have any in-person meetings with Garland? Declined to answer. Any in-person meetings with Jack Smith? Declined to answer. During the September 30th deposition, we sought to understand why he refused to answer these if he already answered them. But he didn't explain. He said, well, privilege, and didn't assert any specific objections. Wyndham's refusal to confirm his prior testimony, despite the committee giving him numerous opportunities, can only be understood as a blatant attempt to corruptly impede our inquiry. I think a jury's going to indict him on that. Says, at the outset of the deposition, Wyndham's counsel provided a list of various objections. Then in responding to particular questions, he repeatedly stated, I'm not answering any questions. By refusing to state his objections, he failed to comply with our rules. Now, despite repeated requests, he did this 70 times. Just blanket refusal to answer. His repeated reliance on these broad brush blanket justifications without any connection is highly suspect and unpersuasive. First, we explained in detail why we want these things, and he doesn't care. He says we got a valid legislative purpose. For example, when asked by the committee to explain whether he was relying on the fifth or the first, he testified. They said, all right, Thomas, so you're not willing to answer any questions about how you prepared for today? I declined. So your counsel illuminated a number of reasons why you might not respond. First Amendment, Fifth Amendment. Is it Fifth Amendment for this question? Decline. Attorney says, and I will add that I think your question invades privilege and work product with the client. I'm not disputing your communications with your counsel. I'm just asking, are you invoking it because of that privilege? Now, the lawyer also asserted that, merely listing a whole blanket list of justifications is enough. It applies to all of them, but they wouldn't confirm anything. Mr. Wyndham won't even answer this. What positions did you hold at the Department of Justice during your tenure there? Won't even answer this question. I decline. Is part of your reason that you're asserting your Fifth Amendment right now? I decline. Okay, well, that's fine. Is it a Fifth Amendment reason or what? I decline. Okay, well, you're objecting to our question on a potpourri of reasons. Now, you may not like this. You may not appreciate that we're here, but we're Congress. We can ask you these questions. We need to know why. Do you understand that you have to give us a reason? Attorney says, I do. Okay, and you haven't given us a reason yet. Attorney says, well, I don't understand your point. He doesn't have to say anything. I've advised him invoke his rights, and he doesn't have to respond to you. Back and forth between him and his attorney. So they move forward. They say, well, you want to answer this question? I decline. And it's his privilege. He's not answering anything. So they say, this is extraordinary. Congress, witnesses may assert their Fifth Amendment rights. Of course, they say. But here, he's refusing to even invoke his Fifth Amendment rights. Moreover, courts have consistently held the standard for invoking the Fifth Amendment rights is if you believe that you might be charged. Now, along with refusing to even answer the basic questions, he used the Fifth Amendment more broadly than he should be allowed to use it. He says he refused to testify about whether he knew DOJ employees who worked there at various times. He wouldn't even list his employment status. Throughout the depot, he invoked the same blanket objection repeatedly. For example, we asked him about how he worked with two other government employees, John Crabb and Stephen DeAntonio. They say, hey, Thomas, who's John Crabb? Decline. Who's Stephen DeAntonio? Decline. Decline. Who was the U.S. attorney when you started your job? Decline. Okay, so testifying that Matt Graves was the U.S. attorney in November, is that something you can't answer here? Decline. Who succeeded Rosenstein? Attorney said decline, and it goes on and on. Decline, decline, decline. Are you currently working as a lawyer? Decline. Nonstop. Now, notably, as a former federal prosecutor, he knows he's not allowed to do this, but despite knowledge of this, he did it because he knows nothing's going to happen. All individuals have an obligation to comply. And so now he is improperly asserting his privileges, and he's trying to do it corruptly to impede our investigation. He's just going to say, it's not corrupt. I'm just worried I'm going to get indicted. So he'll have a plausible explanation for it. I'm afraid you guys are going to indict me, so I'm not answering any of your questions. That changed after I started to see James Comey get indicted, for example. So although the DOJ twice authorized him to testify, he's not. Wyndham's various shifting justifications for refusing this were facially unreasonable and were not offered in a manner consistent with our rules. Now, his conduct can only be understood as an intentional effort to obstruct us. And so we think this is obstruction. We've enclosed documentation of the entire deposition, and we hope you prosecute him. Oh, gosh. What do you guys think? Jim Jordan came out. Here's what he said when he was over on Fox News.
Answer key questions like the fundamental question, was this investigation political? Was it designed to harm President Trump politically?
Yes.
One of his deputies who worked for the special counsel took his Fifth Amendment rights, exercised his Fifth Amendment privilege to that question. We've interviewed multiple lawyers who worked for the special counsel. Two of them each exercised their Fifth Amendment liberties over 70 times. So we want to ask some of those same questions to Jack Smith. And then you couple that, the failure of them to answer questions, exercise their Fifth Amendment right, you couple that with what we know Jack Smith has done and what we've learned of late, like the fact they were spying on 8 members of Congress. Like some of those lawyers that we talked about who took the Fifth were part of taking Scott Perry's phone from him 3 years ago. So you have all that history, not to mention the raid on Mar-a-Lago, not to mention the gag order they put on President Trump, not to mention we've had a defense lawyer for one of the defendants say that he was offered a, what some might call a bribe when he said, we thought you were interested in this judge position. Why are you defending one of these people that we want to investigate in the January 6th investigation? So
Stanley
all
Woodward.
that history is why we think it's now appropriate to bring in Jack Smith and why we've asked him to come in.
They're saying, they're reporting the same. He's now calling on a criminal referral for Thomas Wyndham, and Eric Schmidt, the senator, came out today and he said, yeah, Jack Smith, we need to expand our investigation into him. We know that the senators put in there a little provision to go after Jack Smith and the other people responsible for spying on them. But here's what he says in the aftermath of this referral over from one of Jack's top henchmen for prosecution for obstruction.
I think we should expand it. I actually think any individual in this country who was victimized by Jack Smith at the Justice Department ought to be able to sue in a private right of action in any organization. I think this kind of litigation will help expose this sort of dirtbag that Jack Smith was.
That's
House Republicans want to repeal it. They consider it self-dealing amongst GOP senators.
Well, I think there's a lot of outside organizations. I mean, Turning Point USA, for example, was targeted. And by the way, that's just from the whistleblowers that we know of. There's probably a lot of other individuals and organizations that were caught up in the Soviet-style dragnet that Jack Smith dreamed up in his fantasy of being some sort of hero. He's the villain in this. And so I think more litigation, the better to expose all this. So my perspective is we ought to expand it broader.
Yeah, and hopefully their inquiry continues and we have more subpoenas going out to drag more of these people in to testify. If they don't come in and testify, then they can make criminal referrals over. I don't know if obstruction is going to carry a lot of weight based on the fact that he's just really not talking. And I think a lot of grand jurors would look at that and say, you don't have to talk. You don't have to answer anything. And so the fact that he was talking and then stopped talking, that's now obstruction. Okay. But I think they're going to need a little bit more than that. So hopefully it continues and the investigation reveals more. They'll talk to this person who'll say, actually, Thomas Wyndham did this and did this. And then they can cross-reference that and then bring indictments for the real crimes, not process crimes for lying or obstructing to Congress, but the actual crimes that they were involved in, which were really massive conspiracies against our rights. The same charges that they brought against the president should be brought against them, and we'll keep our eye on this one. But another criminal referral from Congress going over to Pam Bondi. We'll see what comes out of the DOJ.